Hi everyone, welcome to your module 2. Today we're going to talk about the legal research and writing as a part of your US paralegal studies. Now, in this session, we'll dive deeper into the practical backbone of the paralegal work, which is your legal research and writing. Now, whether you are preparing a legal memo or drafting a contract clause or even finding supporting case law, now, these skills define how effectively you can assist attorneys and ensure accuracy in legal matters. Now, talking about what we'll cover in this module, here's a brief. We'll be talking about the primary versus the secondary sources of law, like what counts as binding legal authority and what serves as a guidance. Then we'll be talking about the research platforms, how to use your Westlaw, LexisNexis, and free legal databases effectively. Then we are also going to talk about the IRAC method, which is a clear, structured approach to legal analysis. And lastly, we'll talk about how to draft concise, precise, and professional legal documents. Now, by the end of this module, you'll know how to approach a legal research task from start to finish and how to structure the findings into a professional document. Okay, let's start with what is a legal research. Now, legal research, it is all about finding the correct law or legal principle that applies to a client's problem. Now, this involves firstly finding the legal authority. Now, it is very important for you to locate the statutes, the regulations, or the case law that governs the issue. Now, take for example, if a client asks whether a non-compete clause is enforceable in Texas, what you'll do, your first step here is to find the Texas statutes and case laws that deal with non-compete agreements, right? Now, next step is diverse applications. Now, legal research is not just about your litigations. The paralegals, they use the research to draft the legal memos, preparing of pleadings, ensuring the compliance for business, and even draft contracts by analyzing the enforceability of specific clauses. Now, thirdly, it is about precise question framing. In legal research, you must define the legal questions very clearly. Now, a vague question, it often leads to irrelevant results. Take, for example, instead of just searching non-compete, a precise query would be, is a 2-year non-compete clause in an employment contract enforceable in Texas under the current case law? Like, that is a much more precise question, right? But what this precision does is it saves your time, and also at the same time, this ensures that your research, it is legally relevant. Now let's talk about your primary and secondary sources of law. Now, legal research, this research requires you to understand the difference between your primary and your secondary sources. Talking about the primary sources, these are basically your binding authority. These are the law themselves, like constitutions, statutes, case law, administrative regulations, and the court rules. Now, these are what the courts must follow. For example, a very famous case of Brown versus Board of Education. This is a primary source because it is a court ruling that directly sets a legal precedent. Now let's talk about your secondary sources. Now these are like your persuasive guidance. Now these could include your commentaries, treaties, legal review articles, or even your law encyclopedias. Now these are not just law by themselves, but how do I explain it to you? These help you explain and interpret the primary law. Okay, for better understanding, let's take this example. For example, reading an article on how courts have historically viewed non-compete clauses is a secondary research, but this provides you context, but it is not binding. Now, let's follow a rule of thumb. You use your secondary sources to understand and guide your thinking, but you always cite the primary sources when making a legal argument or drafting a document. Now, you can think of your secondary sources as the commentary during a cricket match. It explains the game, but it doesn't determine the score. Hope the difference is clear now. Now let's talk about the legal research platform. Now to find these sources, the paralegals, they rely on both the paid and your free research platforms. Talking about the paid platforms, we have Westlaw. Now it is known for the vast legal database and key site features, which helps you to check whether a case is still a good law. Then we have your LexisNexis. Now this is similar to Westlaw, but it offers additional analytical tools like your Shepherd's citation, which tracks the case history and the treatments. When we talk about your free platforms, we have the Google Scholar, which is great for finding case law when you don't have a paid subscription. Then you also have Court Listener, which is also a non-profit project which offers free legal opinions and filings. Then you have Justia. This is extremely useful for statutes, case summaries, and free legal information. And a few tips I would like to give you when you are researching or searching for any law. You must always use the Boolean operators like your and not to narrow your results. I'll give you an example. For example, when you're searching for non-compete and Texas and employ, that will give you more precise results. And also, I'll suggest you to filter by jurisdiction and your court level. Now, if your case is in Texas, there's no point reading a California ruling unless you're looking for a persuasive argument. Okay, now let's talk about the famous IRAC writing method. Now, once you've done your research, how do you organize these findings? Now, this is your IRAC method. That is the gold standard for legal analysis. Now, it stands for I for issue, which is your legal question that you're answering. For example, is the non-compete clause in our client's contract enforceable? Then second is R for rule, which laws or precedents they govern the issue. Now you'll cite the specific statutes or court cases here. Then is A for application, which means to apply the rule to the client's fact. And this is where you analyze both the sides. That is why the clause is likely enforceable or why it might fall. Now, and lastly is your conclusion from C, which provides a clear answer summarizing your legal opinion. Using the IRAC method, it ensures that your writing is logical, it is persuasive, and at the same time, it is easy for the attorneys or judges to actually follow. Now, talking about the structure of your legal memo, a legal memo is one of the most common, document as a paralegal draft. Now, it is essentially your written analysis of the legal issue. Now, the common sections, as I've mentioned, include as your headings. Now, these includes to, from, date, subject lines, right? Then is your question presented. Now, this clearly states the legal question, that is, like, for example, can the non-compete clause in the client's X employment contract be enforced in Texas? Then is your brief answer, where you provide a short summary for your conclusion. Usually it is in one or two sentences. Then are your facts, which is actually a neutral statement of the key facts. Then is discussion. Now, this is the heart of your memo, where you use the IRAC method to break down the law and the facts. And lastly, you have conclusion, which is a final restatement of your answer. One tip I'll give you here is always check your law firm's formatting guidelines before submitting a memo. Like whatever structure they're following in terms of a memo, you must always follow that. All right, now let's talk about the best practices in legal writing. Now, legal writing is all about clarity and precision. Now, here are the best practices yet that you can follow. First and foremost, goes without saying, that is, you must be clear and concise. You must avoid unnecessary jargons. For example, instead of saying pursuant to the terms aforementioned, simply say under the contract terms, right? So it is simple, easy to comprehend rather than using a technical jargon that would be difficult to comprehend. Then always use your headings and bullet points. Now this makes your writing easier to scan actually. Then is avoiding of your legalese unless necessary. Now legal writing should be formal, but at the same time be readable. And lastly, cite your cases properly. For example, in Miranda versus Arizona, you must exactly mention the case name, volume number, quote, and the year of its, the citation of the year as well. Now, the poor writing can actually confuse the reader and even harm your case in the first place. Now, when you have a well written memo or the contract clause, however, it can save time and actually prevent costly disputes at a later stage. Now let's talk about the about how to draft the legal documents as a paralegal. Now the paralegals, they draft a variety of documents that could include your legal memos, which are basically your internal documents analyzing your legal question. Then is your client advice letters. Now these are the clear summaries of the legal positions for the clients. Then you have the court filings, which includes the motions, complaints, answers. Now, through these must always be reviewed by the attorney first, and then you have the NDAs, contracts, cover letters, and briefs. Remember, while you may draft these contracts, the final review and the signature must always come from your supervising attorney. This ensures that there is compliance with the professional rules. Okay, now let's take a real world example here. Now you are asked to draft a memo on the enforceability of the confidentiality clause. Now here's how you can approach it. First, you have to research. Now you can use Westlaw, LexisNexis to find the state specific cases where similar confidentiality clause were tested in the court, right? Second is you have to draft using your IRAC method. You have to frame the issue, outline the rules, which are your statutes or case law, apply the facts, and conclude with your findings. And lastly, you must review. That is, you must go over the memo and with your attorney for the final edits. That is how you work when you're given a task as a paralegal. Always, I'll give you a tip: is always log your research keywords and filters. Now, what this does is it helps the attorney verify your search strategy and saves time if further research is obviously needed. Okay, now today let's quickly wrap this module. So today we've explored the fundamentals of legal research and writing, from identifying the sources of law, using the research platforms, to structuring the legal memos with IRAC, and following the best practices in drafting. That's it for today's module. I'll see you in the next